Well, good evening, everyone, and welcome to this event, Compensation in the International Law Commission. The event is generously sponsored by A&O Sherman. I'm Jack Kenny, a visiting research fellow at Biffle and the convener of this event. I have a few small matters of housekeeping before I introduce our chair for this evening. We're not expecting any fire alarms, but if one does occur, please calmly make your way out of the building, following the street behind you, and exit off the Russell Square street that runs down to our right behind these buildings here. At which point there's a statue, a Buddha statue, which is our meeting point. There will be a Q&A at the end of the session, so if you have any burning questions, please keep them written down and keep them prepared for our panel. A video of the event and an event report will also shortly be made available on the webpage for this event. It now gives me great pleasure to introduce our chair, Professor Martins Paparinskis. Martins is a professor of public international law at University College London. And critically for our event this evening, Martins is a member of the International Law Commission and the Special Rapporteur for the topic compensation for the damage caused by internationally wrongful acts. Martins previously served as the International Law Commission's chairperson of the drafting committee, first vice chair and chair. So among a great list of prestigious appointments and affiliations, we're most fortunate to have such a distinguished chair with such a wealth of experience in the work of the International Law Commission. So Martins, welcome. The floor is yours.
Thank you, Jack, for the very kind words of introduction, very generously listing all the chairing titles that had accumulated in my unceasing quest for power. I'm very grateful to the British Institute for hosting it and to A.O. Sherman for their support. I suggest that we proceed in the following terms. When I finish my introductory remarks, I will introduce the splendid panel on my both sides. Then I will introduce the topic itself for about 10-15 minutes to tell you procedurally and substantively what the International Law Commission has been up to in this regard. And then we will have a couple of rounds of questions to our excellent speakers. And in the end, as Jack said, a Q&A session. So the people that we have today with us, and just to mix it a bit up, I will introduce them in reverse alphabetical order. Guled Yusuf is a partner in the International Arbitration and Public International Law Group at A.O. Sherman. He specializes in public international law and international arbitration and has represented states, corporations, and international organizations in proceedings before international courts and tribunals. Guled has appeared before the ICJ and ITLOS and is a member of the PCA, the ICSID panel of arbitrators and conciliators, and the ICC International Court of Arbitration. Next, we have Sam Wordsworth KC, who is distinguished, or at least gray-haired, PIL practitioner and long-term visiting professor at King's College London, lover of English romantic poetry, and hater of excessive or poorly reasoned damages awards. I note in passing that, of course, codification of international law is a serious matter, and I strongly disapprove of jokes in the items. Then we have Professor Christian Toms. Christian is Professor of Public International Law at KCL, decades ago assistant to Bruno Zim and James Crawford during the ILC's work on state responsibility, associate member of 11 King's Bench Walk, and since last year, president of the European Society of International Law. To my immediate left, we have Federica Padeur, associate professor of law at Queen's College, Cambridge, and a fellow of the Lauterbach Center for International Law, a great expert in the law of state responsibility on which she has written extensively. She loves baking and making ice cream and is on a quest to perfect the Canal de Bordeaux this year. Oh, I think that my multilingualist credentials have been immediately quashed. And finally, last but emphatically not least, we have Sir Tim Ike, KC, a barrister and arbitrator at Essex Court with particular expertise in PIL and international dispute settlement. Until recently, he was UK judge on the European Court of Human Rights and was knighted in the 2026 New Year's Honours List for services to the protection of human rights in Europe. Tim has a long-standing interest in the question of compensation. Long before joining the court, he co-wrote the loose-leaf Human Rights Damages Principles and Practice in 2001, trying to make sense of the Strasbourg Court's approach to compensation. During his 9 years at the court, the question of compensation, primarily under Article 41 of the European Convention, was part of his daily bread and butter. In this role, he was involved inter alia as a member of the Grand Chamber in the just satisfaction judgment of the interstate case Georgia-Russia II, and was one of the co-authors of the dissenting opinion in the just satisfaction judgment in Molosali and Greece, who, having complained that the just satisfaction aspect of a complaint frequently receives only the most cursory attention, almost as an afterthought, without detailed exposition of or reference to applicable legal principles, proceeded to set out their understanding of the applicable principles under international law in a little more detail. And if I again made side note, when I spoke to the registry of the European Court of Human Rights of cases that they consider their leading judicial pronouncements, this was the only that I was pointed to that was not the majority judgment. So this is something that has left its impact. So where is the International Law Commission on this point? Let me first briefly outline the procedural journey. For our purposes, the story starts in 2016, when the Secretariat of the International Law Commission included compensation under international law in the list of potential topics for consideration by the Commission. And that was a list that included several topics that were picked up by the Commission, including general principles of law, which was this year adopted provisionally on second reading, and evidence in international law that got to the long-term program of work. One of the topics was compensation under international law, which attracted my interest at the time academically. When I was campaigning for the International Law Commission in 2021, one of the questions that states used to ask was, why do you want to go to the Commission? What is your project? And compensation was the answer that I usually gave to them, mostly because it struck me as something that would be a good thing for the Commission to do. I had recently completed my work on the state responsibility chapter of Oppenheim's piece, which I'm sure will be forthcoming at some point. And one point that struck me that compensation was in that peculiar half-life point where it provided the overall framing for the discussions of the issue, but most of the relevant practice had really happened after the 2000s. So this seemed to be something where the Commission had left a huge imprint, but one might say rather shallow one. So a great deal more could be done. In 2023, in my first Commission's year, I went to the long-term program of work working group, which is the initial process for the Commission's products, and introduced compensation as a possible topic. It usually takes a couple of years for that to go through. So in 2024, the topic was put on the long-term program of work. And the way how it works procedurally, it is then put in an annex to the report of the International Law Commission. It goes to the Sixth Committee and states react to what has been said there. And overall states in 2024 were quite interested and approving. Again, perhaps not quite sea level rise in international level of interest, but overall at a higher level of interest and support. 45 interventions, 33 welcoming the inclusion, and only 2 being critical. Then last year in 2025, the Commission decided to move the topic from long-term program of work to current program of work and appoint me as the Special Rapporteur. And again, states reacted in a broadly similar manner. 40 spoke, and 31 were welcoming, and only 2 were critical. I think I will make 3 broader points on the substance. So one is why should the Commission look at the topic currently? Secondly, what the scope of the topic would be, and thirdly, what substantive issues would fall within the topic. And generally, I have to say that the first report, which I'm finalizing right now, so this is excellent timing for listening to reactions from this very eminent panel, will broadly build on the syllabus that was annexed to the report in 2024. So if you have seen the annex, you will not be shocked and surprised by the overall position I take. So there's only one small point where I will take a different view, which I will flag in relation to scope. So why look at it? And in my view, there are three reasons to do that. First, this is a topic and field in which a great deal has happened since 2001, simply the richness of practice. At the interstate level, in various bodies, International Court of Justice, interstate arbitration, ITLOS, European Court of Human Rights, regional human rights courts, all three regional human rights courts have done very interesting things. And of course, investor-state arbitration, not even going into the further institutional contexts like damage registers, for example. So a very important topic on which more could be said if considered as a singular topic. So essentially doing the same thing that the ILC did under the guardianship of John Dugard regarding diplomatic protection, taking a proposition encapsulated in a single provision of the 2001 Articles on Responsibility of States for Internationally Wrongful Act and unpacking it in much greater detail. The second point is expanding the scope of the inquiry. Within the context of the 2001 Articles, compensation and content of responsibility are addressed, formally speaking, solely in the interstate context. And as a matter of practice and judicial decisions, we now have a wealth of decisions coming from institutions before which actors other than states and international organizations appear in human rights and investment arbitration context. And also there is some practice relating to responsibility of and compensation by international organizations. So essentially taking the rule on content, but expanding it beyond interstate context to add individual claimants on one side and responsibility of organizations on the other. And the third point is really engaging with the richness of application and practice relating to application that has happened over the last 25 years. So that is the argument for why the project is worth doing at this point in this institution, because these are matters that are discussed in many settings, but often within the overall framework of the Commission's work. So the Commission would be well placed to address it at a generalist level, with sensitivity to specialist issues, but ultimately at the generalist level. So what is the proposed scope? And here the core rule that I would be looking at, that the Commission would be looking at, is Article 36 of the 2001 ILC articles. And let me just briefly read it out. Paragraph 1. The state responsible for an internationally wrongful act is under an obligation to compensate for the damage caused thereby, insofar as such damage is not made good by restitution. And paragraph 2, the compensation shall cover any financially accessible damage, including loss of profits, insofar as it is established. So Article 36 would be the core, but the inquiry would also address other rules that are either implicated in principle, like Article 31 on full reparation and 34 on forms of reparation, or are often applied in practice in conjunction with compensation. So Articles 38, interest, and 39, contribution. It would also apply ratione personae, as I previewed a couple of minutes ago, to claims brought by non-state actors and to responsibility by international organizations. It would apply solely to wrongful conduct. So only rules on responsibility, only secondary rules, not primary rules on liability, nor rules that the ICJ recently described as essentially cooperative character and not implicating liability at all. So compensation, and one might say bells and whistles surrounding compensation. So that would be the scope. What are the substantive issues to be addressed? And here, the hard question, in my view, is thinking through how to pose a question in a way that simultaneously captures the basic conceptual framework of law-state responsibility and the assumption that there are general secondary rules applicable in all contexts where international law is breached, and not changing with the nature of primary rules in the absence of lex specialis, and at the same time appreciating and giving effect to the reality that the institutional context plainly matters, that the sort of things that go into consideration of breaches of primary rules in environmental, human rights, war claims, space law, investment law contexts may be different, that the underlying dynamic that drives the policies at play and evidentiary and mandate issues will be different before different bodies. One way of striking that balance is to make the analytical distinction that I did in the syllabus between determination of rules and their application, and essentially suggesting that there is one line of inquiry that goes to greater concretization of rules, so compensation, damage, causality, breach, contribution to injury, mitigation, concurrency, interest, and so on, and another that relates predominantly to application. So best practices of valuation in different fields, which may very well be different, as the ICJ has considered in its different cases, as well as distinctions between the role played by law and other disciplines like accountancy and science. So those were the sort of the three broad themes: the argument for why do the topic at all, why do the topic within the scope, and how to approach it in substantive terms. Let me pose the first question to our panelists, and I will try to pose it in as open-ended and non-loaded manner as possible. So the argument for doing the project that I put forward and that states and the Commission appear to broadly accept, does it make sense for the topic, for the Commission, for the times that we are living in? Perhaps Christine could start us off.
Yep. Well, thank you, Martins. Hello, everybody. It's very good to be on this panel and to discuss this timely topic. Now, is there a need for more work on compensation, general work on compensation along the lines that Martin has just outlined? I would say overall, yes, I think it's a good choice. I think I'm looking forward to seeing what, Martins, you make of the topic. And I think I'm moderately optimistic that this will yield useful clarification and that the ILC can bring clarity and some form of standardization, streamlining to this area. But I think much depends, and this is what we'll discuss later, on how really the topic is approached and what battles you as Special Rapporteur and the Commission in its work on the topic wants to pick, and where it wants to sort of steer, sort of perhaps stay away and sort of let the law develop in its various subfields. Overall, I think a good topic. My main concern is that I'm not so sure whether the ILC's work on this topic will actually be in sort of really streamlining practice. So let me perhaps unpack that in two and a half points, I think. As for the rationale for choosing this topic, I think, Martins, I would agree with the premise. There's certainly room for clarification just because the prior work on state responsibility lays down certain markers, but it's pretty thin, pretty shallow in that particular field of state responsibility. Now, that's less a criticism of the work at the time than of the timing of the work, which was really sort of produced when you could draw on lots of sort of Iran-US claims tribunal jurisprudence, lots of sort of interstate arbitration, but let's say this whole explosion of ISDS couldn't really be reflected. And as I think the ILC draws out, and I think you draw out in the annex documents, there is now a richer practice. So I think that's a good starting point. I think I would say it's a useful choice, a good choice. Looking at it a bit more carefully, I think if we're looking sort of at that richness, which Martins, you mentioned now repeatedly, I think, yes, it's richness across the board, but it's also, of course, it's clustered in particular areas. And that perhaps is my middle point, leading me ultimately to my second and half point, where I'm a bit more cautious about the potential impact of the ILC's work. Now, it's clustered in particular areas. Yes, I think it's, if you're doing sort of number crunching, you can probably say there's a lot more practice and adjudication now on compensation issues. But it's quite unevenly, or it's quite unbalanced and quite unevenly sort of distributed. So you've got the dramatic increase of awards in investor-state dispute resolution. You've probably got a significant increase in human rights law. You could say there's some awakening at the ICJ or interstate arbitration level, but that probably doesn't really justify an ILC 5 years work program. I mean, 3 cases instead of 0, fine, but I don't think the ILC will need it very much. And it's not clear to me, and I don't think the ILC makes that point, that the non-court, non-adjudicatory practice has significantly picked up, sort of diplomatic settlements in which sort of standards of compensation would have been implemented. So I think there is richness, but I think it's clustered in particular areas. And I think that matters because it leads me to perhaps a bit more of a cautious assessment of whether the ILC will really be making an impact. I do hope so, because I do think that certainly in one of the various fields of activity, ISDS, compensation awards are a major source of friction and would desperately be in need of sort of a more sort of sound, rational or conceptual thinking. But it seems to me that a general text that starts out by sort of developing or distilling general principles may not be able to shape, or if you want, rein in rogue practice in particular fields where this follows either specific rules. Just satisfaction was mentioned, which is certainly sort of a particular rule that determines sort of compensation awards, or follows past dependencies and jurisprudence that has developed in certain fields. So that's, I think, then the challenge for this work. If it wants to generalize, and if the ILC's work is meant to shape and bring out sort of general characteristics of the development, which is development in particular fields, then I think it needs to, on the one hand, Martins, as you say, be sensitive to the peculiar demands of the various subfields, and on the other hand, assertive enough to say that there is a general body which may lead you, active in particular subfields, perhaps to reconsider your approach. And I think that requires a skill and tact and sensitivity, but also firmness. I have no doubt, Martins, that you'll bring those skills to the task. But that, to me, seems an open question of whether 10 years down the line, when we look at a sort of an efficiently completed set of ILC's guidelines on compensation, whether they will be good for the teachers of international law, or whether they will also have come to shape international arbitration practice. That's what I would say in opening.
Thank you, Christian. I think that is a great question. I recall, I think it was in 2024. So that was kind of when states had seen the annex, but I had not yet been appointed. And so the question was asked in the trusteeship council of the 6th committee, kind of what do you think about the practical value? And the illustration I chose came from the climate change advisory opinion proceedings, because oral pleadings were just coming up a month after. And I said, essentially, if this project had begun in 2016, and if one were to be now finalizing the first reading or starting the second reading, one imagines having said something on causality and having said something on plurality. Do you think that that is something that would put your counsel in a comparatively more favorable and comfortable space of mind? Again, there as well, it was one of those rhetorical points. Would anybody like to?
Thank you also from me for the invitation to this fascinating panel and topic. As you said, I come from one of those niche jurisdictions, which produces quite a lot of the case law on this at the moment. The court last year handed down 800 plus judgments, which will all have required or will require a just satisfaction assessment. And in your introduction, you rightly noted that in 2001, I wrote at least loose leaf trying to make sense of the jurisprudence, and I failed. I've now sat on the court for 9 years, and as the separate opinion in Molla Salih makes clear, I'm still not sure, and I don't think the court is necessarily sure. So from that point of view, I think there is real value in this work for that niche jurisdiction. But I think it goes beyond that, because one of the things that strikes me about compensation, or as under the convention it's called just satisfaction, there's a point I want to make about that too in a minute, is that there's been an amazing amount of cross-referencing between the various tribunals and courts, the ICJ referring to Al-Jeddah and other cases, and the Strasbourg court referring to the ICJ and to ITLOS and to interstate arbitration and to investor-state arbitration. And therefore, certainly in terms of underlying and fundamental principles, it seems to me a good place to do the work the judges in Strasbourg, in fact, and perhaps on tribunals elsewhere too, just don't have the headspace to do, and gives them a list of principles to which to refer, by which they can adjudicate on what, certainly in the Strasbourg context, is the last thing on the agenda. When on a Tuesday morning you sit in the chamber and deliberate cases, the drafts will have as the very last thing Article 41, and by that stage you will have, that's in 4 cases, and you will have had, your headspace will have been elsewhere. So to have a reference point, which the court currently doesn't have, by which to do that, would be extremely valuable. I think the other thing that would be helpful is, and that's where the language of the Strasbourg, the European Convention is slightly confusing. It talks about just satisfaction, but of course it isn't satisfaction in the Article 37 sense of the ILC articles. It is effectively compensation, and the court has always made that very clear. And I think, again, to kind of bring that together and for the ILC to recognize that and to value that and to kind of enable that cross-fertilization would be certainly from the court I used to sit on, a very valuable and helpful project.
Thank you, Tim. To be balanced, looking to my left. Rika and Sam?
Thanks very much. Yeah, I rather agree with Tim on the absolute importance of this, because the headspace that's been devoted to the issue of compensation has been much too limited. And I notice you referred twice to the richness of practice since 2001. But really, what is the quality of that practice? I don't think it's just a question of it being clustered. I think on the whole, there's a question of it being very thinly reasoned and lacking principle. And I think the odd thing when one looks at the clustering issue is that that seems to be pretty much across the board. With all due respect, one might say some of the ECHR judgments are lacking in that respect. The ICJ judgment gave us all a bit of a laugh in DRC, Uganda, with its 400 million plucked out of the air. And some of the ISDS awards are, there's a lot of paper, but not much serious reasoning. So I think this is a very important topic. And actually, I would say it's got a chance of being the most consequential topic the ILC has looked at since 2001. I did look at some of the commentary beforehand. I just wanted, this particular commentator, I think, has got it just right, recent commentator. Writers have devoted but little attention to the measure of damages in international law, and the paucity of reliable doctrine and precedent has embarrassed recent attempts to codify the law. Such would be of great value to judges and arbitral tribunals, point Tim's just made, because of the divergencies of theory which underlie the measuring of damages, which indeed lie at the foundation of international responsibility. Now, that's Professor Clyde Eagleton writing in the 1929 Yale Law Journal. I would say so little has changed. Sure, lots of practice, particularly since 2001, but how much of it is really going to give you that much? And the difficulty, of course, is that without a sound reasoned basis, particularly in the ISDS field, states are having to pay tens or hundreds or billions of pounds or dollars or euros in compensation. And I think also there is the issue that the doctrine is quite thin. I brought along a copy of the English practice book, which is McGregor. And that there is a sort of an absence of this sort of depth of not just study, but of course this is McGregor is really a practitioner's handbook. It's made up of all the cases, drawing out, bright lines of reasoned principle that are useful for judges and awards. And I think there's a general absence of something like this, which shows the sort of scale, but also the importance of the task you're setting out. I should say that I was told this afternoon that Zach Douglas recently held, or a couple of years ago, held this book up at a conference and said, well, it's really 2,000 pages of toilet paper, which I thought was interesting and probably accounts for the huge rise in sales of McGregor during the COVID years. But I actually don't agree with Zach at all on that. I mean, I think this is an excellent book. Of course, you can't replicate it or anything like that. But it just, for me at least, shows that there is a lot of work to be done in this field, super important work. I'm not saying that, there aren't good writings out there, because some people have made a real effort in this field. But I would say there's a lot of very, very important work the ILC can do here.
Thank you, Sam. All very good points. And I just note that another project that the Commission is now dealing with relates to subsidiary means for determination of rules of international law, where one of the issues considered is the weight to be given to various subsidiary means and the quality of reasoning, the mandate of the institution, and the reception by states and the broader community are considerations there. And I think that they wouldn't equally apply to this topic. Now, an important question to consider relates to the scope of the topic. As I said, the approach taken in the syllabus was to draw the line essentially around Article 36 and certain associated provisions, limited to wrongful conduct and exclude primary rules and liability, and also add essentially claims by individuals and responsibility of international organizations. The one point that, as I previewed, I will be proposing to take a different approach than in the syllabus relates to the issue that the Commission's 2001 articles address in Article 27b, and that is compensation in relation to circumstances precluding wrongfulness, where the Commission says that that rules on circumstance precluding wrongfulness are without prejudice to material loss. Chile made an argument suggesting that this is a matter that could be helpfully considered as part of the topic, and I'm inclined to agree with that proposal. So that is the scope that the syllabus proposes. Is it coherent internally with existing work? Does it strike the right balance? Does it address the real practical issues? Federica.
Thank you for inviting me, insisting that I be here tonight, despite being on sabbatical and much preferring to bake and make ice cream. So I think the scope of the project is coherent, and it is, I think, the attempt to generalize and universalize the rules on compensation, I think, makes sense, particularly because even though the articles of state responsibility are directed at interstate compensation only, at least part 2 of the ILC articles, the truth is that international courts and tribunals have seized on the articles regardless of the area in which they are operating. I think it was Corford who at one point said like somebody's sinking to a plank, like a shipwreck to a plank. And if anything, it's because they do provide some basis upon which to ground these decisions in an area in which, as Sam mentioned earlier, and as Eagleton pointed out back to 1929, there was very little principle to go on. So I think it makes sense to draw the lines the way you've drawn. I think the one caution that I would have is around the topic of international organizations in particular, because the practice that we do have is mostly in the state responsibility context rather than the international organization context. And perhaps just a reminder of the mutatis mutandis premise that underpinned the ILC's work on international organizations whenever they drew analogies with states, not just in state responsibility, but also in other contexts like the law of treaties. The main comment I wanted to make is about the scope change that you have alluded to just now, that you've mentioned just now, about compensation in the event of the successful invocation of a circumstance of wrongfulness, which is a topic that is very close to my heart and about which I've been thinking for at least a decade now. So I do not have firm views as to whether you should include this topic or not in the project. I think it is a topic that requires further consideration because the ILC left it very vague and very open. But if you do ultimately decide to include it in the project, I think what I would like to do now is just underscore some of the complexity that hides behind it, and also flag some of the issues that the ILC might need to address, which stray from the topic of compensation as such. So first, I'd like to say that I do not think it is possible to address this topic, so the question of material law in the case of circumstances precluding wrongfulness, in a general and abstract way. I think the question has to be examined separately in relation to each of the specific defenses. For example, I think it is counterintuitive to think that a state that is acting in self-defense must compensate the aggressor state for material loss caused in the course of self-defensive action. But at least in the view of several commentators, and I'm not sure where I stand on this, it is the intuition is the opposite when it comes to state of necessity. It seems intuitively correct that a state that is acting in necessity should compensate for the material loss that an innocent third state has suffered as a result of that action. So I think that any serious treatment of these questions, so compensation in the case of defenses, will need to be addressed individually, defense by defense, rather than with a general statement. Second, the Commission would need to at least attempt to discuss the question of the legal basis for this duty of compensation. In 2001, the ILC left the question completely open. It considered the possibility, but ultimately rejected it, of characterizing this form of compensation as compensation for in relation to, as a form of liability for acts not inconsistent with international law, which was the way that Julio Barbosa was suggesting it should be considered. So as matters stand now, the ILC refers to this duty of compensation, but it says that it is not compensation based on wrongfulness, and at the same time, it's not compensation resulting from a lawful act under international law. So it's not clear what the legal basis of any such duty would be, and so the ILC would need to explain where this duty would stem from. And again, these might differ depending on which defense you are approaching. Third, the Commission may need to grapple with the distinction between justification and excuse, and I know of a very good book, the best book, not because it's the only one on the topic, that you could read on this. But it is arguable, for example, that just as self-defense, there's no duty of compensation vis-a-vis the aggressor state. The same thing you could think about countermeasures. You might think the same about consent. And this is because all of these defenses operate as justifications. We accept that when there is self-defense countermeasure or there is the consent of the affected state, the act in question is lawful. So it makes sense that we do not think that compensation should arise. By contrast, if some defenses act as excuses, right, they exclude the consequences of the wrongful act, maybe some, but not all, so compensation for material loss would remain, but they don't preclude, so the action remains wrongful, right? So it is possible then to ground a duty of compensation on the wrongfulness of the act and say, well, only justifications do not give rise to a duty of compensation, whereas excuses do. This appears like a neat solution, and it is indeed a solution that has been advocated by some of the literature, but I still think that it is only at best part of the answer. It is not a full answer. And the reason why I don't think it's a full answer is that the most difficult question arising in this area is compensation in the cases of necessity. And necessity is argued in international law as a justification and not as an excuse. So you will still have the problem of having to explain why the most controversial case, so compensation in cases of necessity, would arise, even though necessity is a justification. Now, the last point I want to make is that in this area, the Commission would also be operating largely at the level of abstract and very broad principle. And part of the reason for this is that we do not have state practice concerning compensation in relation to defenses. This is partly to do with the fact that defenses are rarely successfully invoked in international dispute settlement, also because they are rarely invoked at all, and rarely successful. So the limited practice that we have relates to compensation in cases of necessity, and in that area, it is sparse practice, it is equivocal at best, and contradictory very often. Now, the ILC could, of course, help by providing guiding principles in this area, so gesturing towards one or the other solution. But it is worth noting that even at the domestic level, there is no uniform solution to comparable legal questions, and that despite centuries, and I literally mean centuries of thinking, legal philosophers and moral philosophers have failed to come up with an accepted general principle, at least in the case of necessity. Roshan struggled with this question, Pufendorf struggled with this question, the Romans struggled with this question. So it's very unlikely that you would be able to find sort of broad general principles that are applicable across the board. Alan Sugarman, tort theorist at Berkeley, published an article in 2004 titled The Failure of Tort Theory, in which he identified and discussed at least 35 different attempts at solving the problem of compensation in cases of necessity, none of which was satisfactory across the board. So it is likely to be a very difficult task. All of this having been said, taking up the issue, of course, would be significant because if it manages to elicit concrete answers from states about where they think the law is heading, this would at the very least give us some indication of how the law should develop in the area. So this is what I wanted to say about Article 27. And if I have a couple of minutes, maybe I can address one more point, which probably strays more into substance than scope. So you can tell me if you want me to talk about it later or now, but I wanted to address the question of crippling compensation and the comment you made in your report, in the annex, that the Commission might take up the point raised in Armed Activities case, whether in determining the amount of compensation account should be taken of the financial burden imposed on the responsible state given its economic condition. So if you want, I can address that now, or I can leave it for later.
Perhaps we can take it in the next round.
Okay, so let's leave it at Article 27 in context.
A tantalizing promise of things to come. Again, I agree with everything, and only to say on international organizations that there's once again another topic that is proceeding in parallel, led by August Reinisch as a special rapporteur on settlement of disputes which international organizations are parties. And there's some, not overwhelming, but some practice that has been uncovered in the memorandum prepared by the Secretariat on the basis of answers by organizations and states, and in the second and third report by the Special Rapporteur, where he looks at dispute settlement and other practice, both in the horizontal setting, one might say, and brought by private actors. Would anybody else want to chip in on this? Sam?
Well, no, I think it's so interesting what Federica is saying there, but this is on a different issue of scope. But to me, in a way, it's analogous because of the complexity of the issue and the difficulty that I think the ILC is going to have in providing us the guiding principles that are so needed. And that is with respect to causation, because obviously the scope you've defined to yourself is to provide the rules for compensation for the damages caused by internationally wrongful acts. And I would think of causation really as a topic on its own. It's no problem at all that the ILC is dealing with it together with compensation. But I think the fact that you're looking at it in the context of compensation, I don't think that's narrowing the issues in any way. And it is such a difficult area because, again, one sees a lack of legal certainty. So we've got the well-established ICJ test of sufficiently direct and certain causal nexus between the wrongful act and the injury suffered. Well, for me, at least, the word sufficiently is doing an awful lot of work there. And what does this test really mean? I think one could, if one was cynical, say, well, what this really means is the ICJ wants to give to itself maximum flexibility for the next case that comes along the line. And one might have hoped for more certainty coming out of the 2000 22 judgment in DRC and Uganda. And it's quite interesting reading commentators like Vlad Lanovoy, who's writing before that judgment, saying, oh, they're going to develop the issue of causation in that judgment. They have to do it. Well, they didn't. You know, again, it's a very vague and deliberately so exposition of the relevant law. I don't think one can blame the ICJ at all for that, but it just seems to me that that gives you quite a difficult grounding point. And when one looks, Tim will tell us about the ECHR jurisprudence, but if we look at the ISDS cases, what one sees, I think, is tribunals who are crying out for some principles to apply with respect to causation. And one could see that reflected in cases like WWM and Kazakhstan, set aside in the English courts recently on the grounds of serious irregularity, because it didn't join up the two bits, the breach, which it had found, and the damages that it awarded. And you have the slightly peculiar, but I think entirely correct situation where an English commercial court judge is saying, hang on a sec, yes, very distinguished tribunal, but what you say doesn't really work. And one has seen that again in the partial annulment in another case, Alhambra and Kazakhstan. We've also recently had to argue another causation issue coming up in the domestic courts, not dissimilar in nature. And you know, rather as Federica was saying, this is something people have been thinking about, but nothing like in that sort of depth. And actually, the doctrine is quite thin, and people like Lanovoy and Blackafelius have had a go, particularly trying to focus on the vexed issue of concurrent causation, massive issue that comes out of the ICJ advisory opinion. Does it say anything to help us on that? No, it doesn't. And again, one can't really blame them for not doing that because they're trying to keep the space clear for the future. But I think in the absence of that sort of long developed tradition, at least a thought that one sees in domestic law in relation to causation, stemming from Hart and Honoré or people like that in this jurisdiction, I just think you have a lot of difficult work to do, but a very, very important gap to fill.
Thank you, Sam. And of course, some tribunals have drawn explicitly on precisely those sort of thinkers. Iran United States Claims Tribunal comes to mind. I wonder, perhaps, I'm looking at Guled and Christian, we could move, unless there's something like to
perhaps just a very quick remark. I mean, of course, on the scope, the difference versus the ILC articles of state responsibility, as Federica mentioned, is that those articles focused on interstate responsibility and applied by analogy to different circumstances. So I think the challenge here in the scope, of course, will be coming up with guiding principles or rules that will apply to a variety of disputes and to a variety of industries in circumstances where there is an interface with other disciplines, as you mentioned, Martins, whether it's economics or accountancy as well. And the big lesson from the LC articles of state responsibility and their development, of course, is the trick of completing the exercise. So it's developing principles, as Federica mentioned, that have sufficient generality that they can apply in a variety of circumstances, but also provide sufficient utility in various disputes in which they'll arise.
Thank you, Guled. I think that is absolutely right. And I think it's interesting, and I was struck by one of the points that the ICJ made in the climate change advisory opinion, which some people might think is in some tension with the approach it took in Diallo. So the way at least I read what the court said in Diallo was that different rules on content of responsibility occupy the same legal space, no matter who invokes them. So therefore, you can look at interstate and individual state bodies who have addressed moral damages. while in paragraph 111 of the climate change advisory opinion, when there is a nod to Article 33, paragraph 2, one of the next sentences says that if individuals are bringing claims invoking responsibility, everything turns on the particular rule. It's not an issue of general law of state responsibility, which is possibly not exactly the same proposition that followed from Diallo. Perhaps we could now move to the substance. So some of the things have already been tantalizingly touched upon: breach, injury, causality, excessive compensation, interest. So that was one of the issues on which there was a very specific intervention by the Argentinian delegation, which called for caution regarding the persuasiveness of arbitral practice on compound interest. So a great deal of interesting questions. Who would like to go first?
Be very happy to kick
Very
it off.
good.
Well, thank you to Bickel and Martins for moderating today's discussion and my co-panelists as well. I'll be addressing the topic of quantification. Article 36 of the Articles of State Responsibility sets out the core rule. Of course, compensation is due for financially accessible damage caused by the Internationally Wrongful Act, insofar as restitution does not make full reparation, and this may include loss of profits where established. The accompanying commentary is not sparse. It addresses causation, the exclusion of punitive damages, the need to avoid double recovery, and it draws on the classical jurisprudence from Chorzów Factory onwards. In short, the framework exists. What's changed since 2001, which we've touched upon already, is not the principle, but the depth and diversity of practice applying it. When the Commission completed the articles, there were relatively few modern reasoned interstate awards dealing extensively with quantification. Since then, we've seen an expansion of judicial and tribunal engagement with damages across different fora. So the difficulty is not really the absence of material, so the material is dispersed and institutionally uneven, and at times superficial. So the International Court of Justice is uniquely placed to articulate a general framework of quantification in public international law, yet its opportunities to do so have been constrained by the way cases have been presented on occasion. In Diallo, the court dealt with relatively modest sums and proceeded understandably by way of equitable assessment in the face of evidentiary limits. In certain activities, the court confronted environmental damage in circumstances of methodological uncertainty, and very cautiously at that. In armed activities, the scale and complexity of the claims included allegations of macroeconomic loss, which led the court to adopt global sums. So faced with the difficulty of constructing a detailed framework in those conditions, the court has often sought refuge in equity and exercises discretionary power in what it presents as an equitable manner. That's been a pragmatic judicial solution, not what many lawyers and advocates were hoping for it, of course, but that hasn't really lent itself to a systemic exposition of valuation principles. So thus, while the court has applied Article 36, it's not been called upon to articulate a comprehensive methodology of quantification. At the same time, investment tribunals have developed voluminous practice in valuation. They've grappled with discounted cash flow analysis, fair market value, replacement cost, and the calibration of discount rates. Yet their reasoning is often framed in technical and evidentiary terms rather than in explicit systemic ones. Frankly, method selection can appear to be a matter of preference between one expert over another, rather than the application of articulated legal criteria, and the broader structure of the law of state responsibility is assumed rather than examined quite often. So what then could the Commission usefully do without reopening settled principles? First, it could synthesize the now considerable body of jurisprudence on valuation methods. The commentary to Article 36 acknowledges that compensation covers financially accessible damage, including lost profits, but it doesn't elaborate criteria for selecting among valuation techniques. Subsequent case law provides a richer basis for doing so. The Commission could identify structured considerations, whether the asset was a going concern, whether it had an established record of profitability, whether market comparables exist and how uncertainty should be reflected, whether in projected cash flows or in discount rates. I'm sure many investment treaty practitioners have encountered business plans of dubious origin, undated of some sort or another. Second, the treatment of lost profits could be clarified in light of practice. The commentary recognizes their recoverability where established and warns against speculation. Modern case law reveals recurring tensions, the evidentiary threshold for proving profitability, the handling of probability and risk, and the avoidance of double recovery where future income has already been capitalized in an income-based valuation. So a careful synthesis of this jurisprudence or case law would enhance coherence without altering principle. Third, the Commission could address the question of valuation date and the admissibility of subsequent information. Article 36 in its commentary don't fix a rigid rule, and practice has oscillated between valuation at the date of breach and valuation at the date of an award or decision. Courts have sometimes used subsequent information to refine their assessments as well. Fourth, interest. Article 8 deals with interest separately in the commentary, acknowledges its compensatory function. Since 2001, however, tribunals have diverged on compound interest and rate selection, and quite often you find advocates referring to one trend or another, whether simple or compound interest is more popular at a given point of time, and a more rigorous approach would obviously be welcome. And finally, quantification must be read together with the limiting principles already recognized in the articles, notably causation and contribution to injury under Article 39. The commentary addresses these doctrines, but subsequent case law has demonstrated varying approaches to apportionment and mitigation in monetary terms. The point, therefore, is not that Article 36 is deficient. It established the essential architecture, as Martins mentioned. Rather, the jurisprudence, the case law since 2001, provides a much richer body of material from which more detailed guidance on quantification may now be distilled. The International Court of Justice has not, for institutional, procedural, and pragmatic reasons, articulated a comprehensive framework, and has at crucial moments been able to fall back on equity and discretion. The International Law Commission, unfortunately for Martins and his colleagues, will not have a get-out-of-jail-free card, not least because, as Martins admitted earlier, it was a campaign promise to address compensation. A good politician would have told them you don't need to keep campaign promises. A focused elaboration by the Commission on quantification would thus build upon, not displace, Article 36 and its commentary, translating principle into a more systemically organized account of how international law converts injury into monetary terms.
Thank you, Colette. Again, I agree with everything that was said. Sam, Tim?
I think what I just wanted to do is kind of take a step back and reflect on the issues that trouble the judge most when you, and I can only speak from the court in Strasbourg, but the issues, and this is a bit of a catch-22, which is I think why we'll certainly most of us agree that this is a really important issue. Quite often, I complained that it was an afterthought for the court, but it frequently, certainly in the Strasbourg court, is an afterthought for the parties too. And that is in part because there are no principles to which they can either plead or produce evidence. And I think that's one of the reasons. And Sam mentioned the kind of rather broad test adopted by the ICJ, and we had the reference to equity. That's why I think a court is between a rock and a hard place. You haven't got the material to actually do a principled assessment because everybody asserts different principles and nobody's pleaded to the same principles or produced the evidence to the same principles. And certainly in a busy court like the Strasbourg court, there then isn't, as I said earlier, the headspace, which is why I think something coming from the ILC, which will hopefully guide the courts and counsel, will also then enable the courts to be more structured, more principled in the way they approach it. And I mean, one of the many things is I mean, we of course have, you know, the pecuniary damage and the moral damage on the non-pecuniary damage, which is a big division in the court. And pecuniary damage, the issue of causation, and Sam has spoken at great length, is an issue which the court always grapples with. And again, in absence of detailed pleadings, it's quite difficult to see a single strand as to how causation is assessed. And whenever the court has, just like the ICJ, whenever the court has had an opportunity, and this is one of the things we complained about in Molla Sali, it's dodged it because it's actually too complicated, dare I say it. It probably is too complicated an issue to engage with at that kind of, as I said, last thought of the day stage. So causality and causation is really important. there, for me, interestingly, looking at different cases. Of course, most of our case law is individuals complaining about the breach of their rights. So in a sense, you would have thought that proof and pleading is easier because you can identify the loss of that individual in one way or another. But of course, most of the interstate cases the Strasbourg court gets is about administrative practice, and it's about a global policy which was in breach of, or an activity which was in breach of the convention, where the individual victims are not always fully identified or capable of being fully identified. And that then leads to courts, I think, picking on equity and picking out numbers and leaving it to the states to distribute the pot that is given to them, to the victims that are subsequently identified. Always avoid making clear that double compensation has to be avoided. And of course, in Georgia, Russia, number one, just satisfaction, that led one of the dissenters, well, one of the concurring opinions, to assert that actually what the court had done in doing that was to award punitive damages, because actually it hadn't been able to identify the individual victims. And there were discrepancies in the figures of people affected. And therefore, having picked out a sum, it was asserted by one colleague that that was awarding punitive damages, where of course the court has always made clear that they aren't available. So that's a real issue. The causation in those kind of cases. The concept of equity is one which, and again, you struggle certainly at the court. Different people have different views of equity. And when I sat in deliberations, people suddenly invoked the concept of equity, which had no relation at all to the concept of equity as I understand it. And that becomes really difficult. So again, I think guidance would be very, very helpful. So those seem to me to be some of the most important things, which would enable a more coherent, more consistent approach by counsel pleading cases before the court and by the court to do it. I agree that quantification and quantum is an important issue where probably different areas go in very different directions in the approach they take. I mean, anybody who's looking for a major damages award wouldn't come to Strasbourg. And that's in part because it is rather conservative, but it has, again, no rules on quantum. And just as some, of course, say that ISDS has gone too far one way, there is an argument that the human rights courts have gone too far the other way. And again, I think the ILC, by looking at principles as to how to approach quantum, could help bring those at least closer together.
Thank you, Tim. Yes, I think that there was that very nice line by Judge Greenwood in Diallo about the importance to have an overall coherent approach to the same legal issue across bodies and institutions, that they can be compared in an intelligible manner. Sam?
Thank you very much. It's interesting. I think Christian started out saying that this was a good and a sound topic, which sounded to be a bit like giving it 7 out of 10, maybe 7.5. I think some of us are definitely more enthusiastic and really see the need for these lodestones to be put in place and feel their absence quite acutely. I'd just perhaps like to say a word on quantum. There is an old joke, in fact, it was Johnny Vida's favourite old joke, which is that there are only 3 sorts of lawyers: those that can count and those that can't. Boom, boom. It's a very good joke. And it's an important joke because I, for example, am definitely in the non-counting category. But I think probably, a good 90% of most international arbitrators trying to interpret and apply standards on damages with respect to treaty breaches are in the same boat. And I think that really creates a problem for us. I'm very interested in what Guled is saying, introducing the topic of DCF. So what does the 2001 commentary say on DCF? It says, difficulties can arise in the application of the DCF method to establish capital value in the compensation context. The method analyzes a wide range of inherently speculative elements, some of which have a significant impact on the outcome, using discount rates, etc., etc. This has led tribunals to adopt a cautious approach to the use of the method. Hence, although income-based methods have been accepted in principle, there's been a decided preference for asset-based methods. And so, bearing in mind what Goulet has said about, how frequently tribunals are having resort to DCF methods, well, why is something or a series of factors that are inherently speculative in 2001, how come they're no longer inherently speculative? And I wonder if that's something that the ILC could look at. And of course, this really, really matters. It matters across the board, but it matters in cases that we all know tolerably well, and some of which you picked up in your crippling compensation paper, like the Tethian case, where you have a project where the investment is $260 million, but the tribunal, this is an experienced and distinguished tribunal, it orders damages in the amount of 4 billion plus 2 billion interest against Pakistan. And my point is not just, how on earth in any realistic world is Pakistan ever going to be able to pay for that, or would it ever be able to pay for that? But also, how and why did an experienced tribunal get to that result? I can think of lots of answers. And I don't think one should always just leap and think, well, hang on a sec, this is the tribunal not doing its work. It's got bamboozled, or whatever a politer word is for that, by such and such an economic expert with a degree from Harvard and such a forensic accountant. But also, counsel have a real responsibility in these big ticket cases to be ensuring that they are correctly interrogating models that seem to be absolutely designed to be incapable of interrogation. So it's a lot of work for a tribunal. I see the ILC commentary here refers to the good old days of the Iran-US Claims Tribunal decisions. And that reminded me of 100 years ago when I was on a case called LATCO. And in LATCO, what the tribunal did was to appoint an independent expert in order to value this vast oil field in the Persian Gulf and come up with reliable, insofar as it was possible, estimates of how much oil would have been got out of the ground under the 25-year concession period, what the value of that would have been. That involved seemingly interminable submissions and hearings in front of the independent expert under the supervision of the tribunal. But when you're talking about hundreds of millions of dollars, well, isn't that actually a very, very useful exercise? So that makes me come back to, I can't remember whether it was Tim or Christian who said this, just the need for the ILC work on this to be quite assertive, I think was the word you used, quite directive in terms of not just, looking at the wards for a careful synthesis, as Goulet mentioned, but actually digging in and saying, well, hang on a sec, how reliable are these results that are coming out? And what can we suggest, or what hooks can we put into our draft conclusions, whatever they are, that counsel can latch onto so they can persuade tribunals to slow down and take a very, very, very careful look at how they quantify damages?
Thank you, Sam. Again, all very good points. Federica, I'm passing on to you on the question that was promised.
Thank you. I mean, given the time, I don't know if you prefer to go to questions.
Perhaps we could just have a kind of the final comments and then
So it's just really brief. I mean, it's a brief point on a complicated issue. I think you've written wonderfully on the topic of, the extent to which the economic situation of the wrongdoing state must be taken into account in establishing the amount of compensation. The reason I'm raising this is because as a matter of political philosophy, it is broadly accepted that individuals, citizens, pay out of taxpayers' money for the wrongs of their leaders. And this is just the way societies function. There is work in what I now know is known as social metaphysics that discusses the circumstances in which collective groups can be considered to be acting as a single agent. And these insights have been put to work in political philosophy to justify the reason why citizens must bear the burden in terms of finances and taxpayers' money, which then doesn't get put to work in, say, the NHS or fixing streets or improving education for the local population. That money has to be put to paying for the wrongs of the leaders that they elect. Now, the political philosophy discussion here often tends to distinguish between dictatorial regimes and democratic regimes, which is a distinction we can't make in international law. But it is a foundation of the law of state responsibility that this is how state responsibility works, to the point that international lawyers rarely question this very premise. There are, I think, only 2 articles written on this topic, one by James Crawford with Jeremy Watkins, so a legal philosopher, and one by a political philosopher in a recent collection by Samantha Besson on theories of state responsibility. So when you're pushing the idea that perhaps states shouldn't pay the extent of damages that they have caused because of certain economic situations that they must be dealing, you're actually subverting this very premise that has been amply supported in political philosophy. Now, the reason why I said this, I am sympathetic to the argument that you were making, partly because of awards that, as Sam has mentioned, are exorbitant. Interestingly, when James Crawford was writing with Jeremy Watkins, I think the highest award that had been given at that point was for $10 million, which they mentioned specifically in this article from 2010. Things have changed considerably. And I think our intuitions might change about the extent to which the economic situation of the wrongdoing state is relevant when we're dealing with, for example, foreign investors against Venezuela being owed $10 billion. But it might be a very different intuition when we're trying to say, for example, that the Russian citizenship shouldn't bear the burden of Russia's damages caused to Ukraine. So I think the answer is, one, to be very difficult, not just because, as a matter of legal philosophy and political philosophy, we are subverting basic principles upon which state responsibility is based, but also because there are really complex questions to address. What is the economic situation of the state? How do you assess the economic situation of the state? And 2, ultimately, damages have been caused, and the question is who should bear the burden of those damages? And it seems rational and logical and consistent in a system of state responsibility that is grounded on the idea of wrongfulness, that the state that has committed the wrong is the one that should pay. Because ultimately, if they don't pay, it is the citizens of the injured state that will bear that burden. So just to raise the point that it is a very complex question, and one that probably goes beyond just the question of taking equity into account or the economic situation of the responsible state. So I don't have answers, just questions, but there we are.
Okay. Yes, Christian.
Maybe just 2 points really on that, what should be covered. One is an echo of what Bulat and Sam also have said. I would really think that valuation should be in. I can sense the sensitivity that, I mean, UDEX, non-calculate logics and all those trials from we all want to steer clear of that. But that's really where I think the law at the moment fails to direct. And that's the biggest normative gap. So I would hope that the Commission, despite the fact that it will probably also have 90% of lawyers on it who are not keen on math and those sorts of things, resist the temptation of just leaving that or continuing to leave that to the valuators, because I think that's the biggest gap that cries out to be filled with normative common sense and a bit more prescription. Second point that hasn't been mentioned, so I just sort of mention it as a topic. I think contribution to injury features in the synthesis, and I think also in your sort of plan of action, as it were. And I would also think that that is something where this particular work can do a lot of sort of useful, sort of contribute, dare I say, sort of usefully, not to the injury, but to clarity, because that also seems to be out there in Article 39 but I think a lot of, in terms of mixing metaphors, meat can be put to those bones of Article 39. Thank you.
Thank you, Christian. And I suppose in relation to ILC members and math, because the process is an electoral one, at least in one setting, math is very important. So perhaps there is a greater enthusiasm about counting at least 193. I think we could perhaps move now to the questions. We might have about 10 minutes or so. The traditional manner, indicate your interest by body language. I see 3 hands, so perhaps we could take in that order 3 questions altogether. And could you introduce yourself? And the microphone is coming.
Does it work? Yes. My name's Rodney Neufeld. I work for the Canadian government, and we argue mostly ISDS cases. I've had a couple of damages cases that I've had to argue, and Resolute and recently in Ruby River. I heard an awful lot about guidance to tribunals, which I think is, of course, welcome, and it seems to be the focus. I heard only very little about guidance to the litigants themselves. And I can say from experience that the cases, so $10 million in damages, they don't go under 500 million in requests anymore. That they cost at a minimum $2 million to litigate because the valuation experts just simply cost that. And usually it's all for nothing. Like usually you get an award at the end of the day that doesn't even address damages because the tribunal just doesn't have to go there on the merits. Surely that's a waste of taxpayers' money and everybody's time and energy. So I'd pitch that as something to consider as an additional issue. The other element another reason that cries out for guidance for litigants is that all too often still there are confidentiality requirements placed on this information, and there shouldn't be. This is, again, from a state's perspective, taxpayers' dollars. So having important portions of an award blacked out when there is an award is helping nobody, and something the ILC should also be conscious about. And then finally, just a comment of what should not be on the award, and I didn't hear it today at all, which maybe I just missed it. I wasn't paying attention, possibly. Still jet lagged. I just came in from Ottawa this morning. Moral damages. I know that's come up in the past, and it kind of scares us. So anyway, but I would welcome views on it. Thanks.
Thank you. Manuel?
I am Manuel Casas from 20 Essex, an engineer school dropout, so a lawyer that counts. Very short question. What percentage of the problems that you have identified in this excellent panel would be solved if we simply banned the use of DCF or modern DCF methodologies when assessing damages?
Thank you. And then there's a hand at the very back.
I guess my question follows from the previous one in that I was struck as well when I read Martin's in the annex that one of the legal questions that you were aiming to discuss following from the 2016 work paper is the calculation of fair market value. Now, it was interesting that it was characterized as a legal question, and what my question that follows from that relates to is whether you see that there are limits to what the law can actually comment on. And this principally relates to my query on whether there's anything more that can be said on fair market value than what the Articles of State Responsibility, at least the commentaries to it, already say, which is the fair market value of a property depends on what the property is. To that extent, my question is, how do you view the principles that apply to fair market value to being legal questions as opposed to being questions of valuation, including the fact that more recent treaty tribunal practice only relies on international valuation standards and codes such as that while addressing that issue and not really legal principles? Thank you.
Thank you. Perhaps I can look first at panelists who might want to react.
Sure, yeah, just on the first two questions, a few thoughts, I guess. I mean, certainly in circumstances where there are articles dealing with compensation will have not only an impact on tribunals, but counsel naturally as well. But, you know, a number of the concerns you've raised do echo on a number of matters I've worked on. I remember one instance where we were acting for a state and tribunal asked the investor, if you were unsuccessful in, let's say, circa 50% of your claims, what would the valuation of the claim be? And they came up with a larger figure, which tells you a lot about practices from time to time. The other element is, I mean, we've really evolved into an environment where the primary remedy in international law is pecuniary and not non-pecuniary. And the role of restitution is rarely interrogated. There was very interesting cases, perhaps two of them, one most prominently against Zimbabwe, where it was dealt with. And the tribunal took the approach of awarding restitution in the first instance, so returning the investment itself. And in the secondary, if there wasn't a return of that within a specified time period, then compensation instead. But I expect that approach or that claim will not be frequently seen going forward, given rising costs of claims. So there will be a preference for pecuniary remedies, especially when you see the increased role of third-party funding as well and a significant return in those investments. I'm not sure that we'll see many claimants approaching it in that way.
Thank you. Do I see anybody else, as it were, on the left side? Geographically left, that's the line that Claudio Grossman, my colleague, always is in the commission.
Well, maybe just one comment, which is sort of tries to situate those three questions. I think one of the risks, of course, that the ILC is now asked to sort of do essentially sort of an ISDS sort of reform exercise. And from Martin, from what you said in opening, I mean, if the aim is to have general principles, then there's limits to what the ILC can achieve in that from that lens. So the responses given will have to also be relevant for human rights litigation, for interstate litigation in the classical sense. And I think then, therefore, some of the responses to either the questions or the concerns that you express are probably rather found in the UNCITRAL working group or in the UNCTAD study or in other fora. But I do think what the ILC can probably bring out, even with a more general lens, is perhaps draw attention to the unusual character of some of the sort of remedies, designs, or compensation practices that have emerged, and perhaps that could be a useful thing. And I would see, in that sense, I mean, will the ILC rule out DCF, to take up your point? I assume not, but maybe it draws attention to the fact that this is not the standard method and that it also requires rational explanation and comes with drawbacks, reconnecting with the part of the commentary that Sam quoted a while ago. So I could see useful contributions from that perspective too, but perhaps to restate that again, it's not an ISDS reform exercise, I would have thought.
Well, I mean, Christian's just said everything so well. I hesitate to add. I was just going to come back to your point on bifurcation. And it's the same sort of thing, same sort of answer, which is that one could imagine a world in which the ILC commentary said something like, given the increased recognition of the complexity of damages issues, courts and tribunals are increasingly deferring these to discrete procedural stages with the sort of money-saving, potential money-saving knock-on effect. And that sort of language, of course, for the practitioner can be incredibly helpful.
Can I perhaps just, because it's interesting in relation to the first question, the issue of bifurcation, because it seems to me, certainly the experience of the Strasbourg court is, historically, issues were always separate. There was always a separate procedure for just satisfaction. And the busier the court got, the fewer of those bifurcated hearings we had. So in my 9 years, probably probably no more than two handfuls out of about 950 cases I sat on that were pure just satisfaction cases, pure compensation cases. So they tend to, I mean, the busier I think jurisdictions get, the more likely the economy of managing those proceedings will require them to be put together. But again, it comes, I mentioned the fact as a judge, I was frustrated by litigants not helping us. And that's in part, the pleadings and the evidence wasn't good enough, but it's in part also, and this is where it's a catch-22. And I think to some extent, my hope, kind of wearing the former judge's hat, is that the ILC can kind of slightly retrofit the principles on which, you know, some of the work the courts have done works. Is that, of course, at the moment, we also find a situation where certainly the Strasbourg court will say, well, you only asked for X, even though we would have given you Y, because you only asked for X, we're not giving you any. So actually, there's no incentive at the moment. I mean, you know, Strasbourg isn't a big money jurisdiction, but there's no incentive at the moment to do that. The other thing you mentioned, moral damages, is something that scares you. But again, I was struck by the fact how, you know, you mentioned Chris Greenwood's declaration in the Diallo case, that kind of, how there was that confluence. And if this is an exercise, in part at least, of kind of putting principles on something which certainly the Strasbourg court has done routinely, then of course we do moral damages quite a lot, but they're not, in a sense, I assume, and you'll tell me I'm wrong, but they're not as scary as they might be in an ISDS setting. And therefore, if there were, again, principles that can inform, and I take Christian's point about the differences, but can inform all of our kind of international dispute settlement, then actually that may be a kind of helpful influence from the human rights field in other areas, where actually that's the kind of starting point at least, which then would also perhaps make governments in other areas feel more comfortable that actually that is part of the package.
Thank you. I mean, I listened with great interest in all these points, and I mean, this is a beginning of the process, and the steer of states or the Sixth Committee will be a helpful indicator about the direction that we should be going. I think that there is a sense that the Commission should certainly not be duplicating the work that is going on elsewhere. That it could well be that there are particular practices in the environmental valuation community. Ancestral reform has been mentioned several times, and indeed, I think at least 5 states in their observations in the Sixth Committee explicitly drew attention to the fact that such developments are there. And I think that conversely, recent ancestral documents already making back a reference to the ILC work. So I would rather see it as a inductive development, not necessarily as something where there's a single right answer, but I think that that is the tension between the proposition that there are general secondary rules and it makes sense to speak about them in a cross-cutting generalist manner, and at the same time appreciating that different specialist fields and different institutions address them in a different way. In my view, as I said, the sort of the distinction between determination of rules and their application, roughly what the ILC did in 2001 with the provisions and the commentaries, is the way to strike it, of explaining how the things might work very differently in different fields, that one can, you know, look at the Corfu Channel for looking how war damage from mines can be addressed, and not be surprised that Corfu Channel doesn't come up in Diallo in relation to arbitrary deprivation. Different fields have different rules. Yes, I think perhaps just as a very small point, moral damages is something that is within the topic. It is within the ILC work. I think perhaps if I can be somewhat cryptic, but I'm sure that the audience would appreciate the reference through the lenses of Judge Greenwood's declaration. So the question whether we are sort of coherently reasoning through similar ones in a principled manner. It may well be that human rights cases have a slightly different approach to moral damages than a case where the claimant came from a region that certainly is very far from the rather wet afternoon and evening that we are having, perhaps in a slightly where the lines are drawn in a slightly drier manner. So the question whether this is also the same universe of reasoning is an important one. And I think that Judge Greenwald's point about the systemic coherence that ILC should ideally be sufficiently flexible to provide that nuance without flattening the complex landscape, but at the same time preserving the value of generality would be the point where to go. So we have slightly exceeded the time, but I think that this might be the point to draw the line at it. Over to you, Jack.
What about the answer to the last question?
Sorry, the last question.
I think it was gathered off, but fine, I won't belabor the point.
Calculation of FMB.
Yes, so in my view, so one of these is, and again, perhaps not to oversell, that these are issues that would be addressed. I'm a special rapporteur. Ultimately, these are things that come out of the whole Commission's consensual work. In my view, this is an issue that would be addressed as an important matter of application of relevant rules, and application of rules gives us much greater flexibility to look at evidentiary and mandate considerations beyond the more abstract, vaguer formulation of the rules. So that is certainly within the process. And the question of delineating issues of law and others is absolutely a question of law. The Pecasado II tribunal, I think, said some helpful things in that regard regarding law and evidence and verdicts. I think here we will draw the line. Jack.
Thank you. And I hope you'll all join me in thanking the panel and our chair for this excellent event.